We've been discussing the long-term, long-stay repayment scheme in the context of two distinct groups, if I'm correct in terms of what Mr Mulvaney is saying. So we have the medical card holders in public nursing homes who largely were eligible under the scheme, and medical card holders in private nursing homes who the HSE and the department have contended are outside of the scheme. That's correct? Okay.
The HSE is not contending they're outside the scheme. The Dáil, the Oireachtas, approved the 2006 Health Repayment Scheme Act. Okay. That Act set out the scheme. That Act and the Dáil and all the parties in Dáil agreed through that process that the eligible criteria was you had to be a medical card holder.
Okay, no, you said that.
You had to be in a public CNU, community nursing unit, or in a publicly funded contracted bed in a private nursing home.
Your point is made. But there was a third group, isn't that correct? Because there were also medical card holders in what are known as Section 38 and 39 disability services homes, all community hospitals essentially, isn't that correct? So if I could just refer you to the financial statements of the HSE from quite a number of years, 2009, 2010, but I'll read from 2011. It says, in addition, the HSE with the Department of Health has lodged an appeal to the High Court in respect of the determinations by the appeals officer granting eligibility to clients in certain disability services. Consequently, it is considered inappropriate to attempt to estimate a future liability arising from these actions. So essentially what we know from your annual statements is that there were residents in these community services, disability services, who applied for the scheme, were deemed ineligible, and then appealed it with the appeals officer within the HSE. And the appeals officer took three, as I understand it, test cases that related to services at St Michael's House, Cheverstown House, and the Daughters of Charity. And he determined on the basis of those three that those residents were actually eligible under the scheme. And the HSE and the Department of Health actually initiated an appeal against their own appeals officer through the court's service. Are you aware of any of this?
Not aware of the details, Chair, no.
Okay, so I've read the 2011 accounts, and that was the case 2009, 2010, 2011. The HSE has lodged an appeal to the High Court. But by 2012, the note 31 in your financial accounts, it says, following discontinuation of appeals to the High Court brought by the HSE and the Department of Health in respect of determinations by the appeals officer granting eligibility to clients of certain disability services, €8 million has been provided in the 2013 HSE budget to fund repayments for outstanding claims. So essentially, it was accepted that these people qualified under the scheme. So you accept that?
Oh, absolutely, Debbie. I don't have the detail, but as I said, the scheme was set out in legislation. The HSE operated the scheme. If the issues you mentioned there clearly arose and were resolved between those 2 years, and some additional people who we didn't feel, or the scheme administrator didn't feel at the start, were eligible, were deemed to be eligible, and that's as you know, there was substantial amounts of money.
I'm surprised you don't know this, because this is included in a number of, even the CNAG's report of September 2011 noted that a hearing in this area is awaited. As I mentioned, the 2012 financial statements provided for €8 million in the 2013 HSE budget to refund repayments to these outstanding claims. €8 million again was allocated in 2004. 4 million in 2014 and 4 million allocated in 2015. Can you tell us if that money was actually paid? If they were the amounts that were actually paid?
Debbie, again, just to be clear, I absolutely accept everything that's in the HSE's accounts, and that occurred, those issues occurred and were dealt with. I can't tell you whether any specific amount that was contingent in 1 year was paid the next year. If you want to give us a specific query, we can go and check that. But I've no doubt that the bulk of them would have been paid, as is the normal practice. There's no issue of, accounting lack of clarity in any way around the administration of the repayment scheme.
So do you know why the appeal was dropped? Why? So the state was going to appeal its own appeals officer in respect of these particular cases. So as I understand it, there were potentially up to 10,000 people across all homes, but over 300 had lodged appeals, and they were going to be deemed eligible as a result of the appeals officer's decision. The HSE and the Department of Health decided, with ministerial approval, we have to assume, to appeal that decision, and then decided to withdraw their appeal. Do you know why that appeal was withdrawn?
I don't, Deputy, but in the first place, the reason we would have considered an appeal or made an appeal to the High Court is generally only to clarify a legal point, to make sure that we're properly implementing the wishes of the Oireachtas as set out in the legislation. That's the only typical reason why we would do that. If it subsequently transpired through legal advice that clarification could be got another way, that may well have been why that was withdrawn. But it's entirely done to make sure.
Let me help you.
If I just finish, Deputy, it's entirely done to make sure that we can attend at the Public Accounts Committee and say that we've done the job that the Dáil has asked.
So let me just clarify. There were 515 similar appeals to the 3 tests that the appeals officer at St Michael's, Cheverstown House, and the Daughters of Charity, and they were, these were residents within those institutions who appeals had been made on their behalf. So, as I said, an appeals officer had determined that they were eligible. It was a decision was made to appeal that, but then that appeal was withdrawn. You say you don't know why. We now have a memo that was circulated to senior government members in 2011 that actually sheds light on it, because this states that the state is likely to have difficulty successfully proceeding with these appeals. It has been estimated that an additional funding of €20 million would be required to implement the appeals officer's decision, which it would account for the provisions in your subsequent accounts. But in addition, there are other institutions similar to St Michael's, Cheverstown and the Daughters of Charity with residents who would have similar potential claims. Can you tell us whether or not contact was made with those people who applied for the scheme but didn't appeal that decision? Was provision ever made to actually provide payment to them?
So, Deputy, I can't tell you that now as I sit here. What I can tell you was, as I said, the scheme was based on the legislation in the Dáil. The Dáil specifically would have said public nursing homes or contracted beds, publicly contracted beds in private nursing homes. Therefore, the emphasis clearly was on older persons, typically who reside in those facilities. And what was clearly raised along the way was, I'm sure, an entirely valid question as to whether people in a similar situation, albeit in disability services, should be entitled or not. I don't have any more detail than
well,
that.
in the memo that I refer to, and this will outline the legal rationale, it says the particular difficulty with challenging such a finding by the appeals office is that it raises a wider issue that the legal basis under which payments were collected from residents in community homes, if it were found by the High Court that they were not recoverable health charges. There appears to be no other legal basis for the levying of such charges. So this isn't a grey area. In terms of the legal advice and in terms of the information that was provided to ministers, this was a slam dunk. The state was liable to pay for them. But, as I say, many people, other than the 500 odd that I've mentioned, and according to this memo, probably on the basis of advice from the HSE that the payments did not come within the definition of the recoverable health charges, decided not to appeal. If these cases were to materialise, it would have had to create a potential liability of some 360 million. But that liability has never been included in your accounts. So what I want to know is who received payments in respect of Section 38 and 39 residential care in terms of the long-term payments, because provision was made for around €20 million, which according to the average that you have just cited to the previous deputy, would work out as around those 500 people who made appeals. But we know there were almost an additional 10,000 people who qualified, who had applied, but who didn't appeal on the basis of advice from the HSE. Has any measure been taken to ensure that those people are actually recompensated?
The scheme is the scheme. The scheme is...
These people are eligible for the scheme. That has been determined by your appeals officer, and a decision that you didn't appeal on the basis of legal advice saying that you didn't stand a chance in hell. So there are potentially an additional 10,000 people to the people we've been talking about all week, and these are people who are in disability services, section 38 and 39. Are they going to now, or is provision going to be made in order to ensure that they are actually compensated as per their legal entitlement?
If I could say, Deputy, if I need to finish here, if I could say, so unfortunately I don't have the detail nor the documentation that you have in front of you. I'm very happy to look at it.
Just for clarity, the documentation I have in front of me is your own financial statements on an annual basis, and the notes, note 31 of 2012, note 31 of 2011, note...
Apologies, if I could answer. Those financial statements and that scheme have gone through both the auditing process and the Public Accounts Committee process since 2007 to date. Okay? What I'm saying is the specific issue that you're raising, I need to go and understand better and brief, and I'll be happy to answer questions at a future point.
Can I just finish on this point?
Can I just make a suggestion?
But to be clear, the scheme was operated in accordance with the legislation, and the scheme is not quite closed but largely closed.
This is the difficult. I need to just make this point.
Mr. Brady from the department, has he any information on this when you're finished?
Okay.
Just briefly finish up because we're going to over time.
So here's the situation as we know it. Up to 10,000 people in these homes were eligible. Number of them appealed. That appeal was upheld, but because of delays as a result of a court challenge that subsequently didn't materialise, it was a number of years before those people who appealed were paid. But there were a number of people who applied in the first instance who didn't appeal based on the advice of the HSE that they didn't stand a chance, where your own legal advice was that they would actually win those cases and should fall under the remit of the scheme.
And the up to 10,000 figure is a figure, Chair, that I don't know, and therefore that's not a fact that's been confirmed here today. That's an assertion that the Deputy is making. I don't have the detail, Chair.
Mr. Brady, can you shed any light on this as representing the department?
I unfortunately can't hear. Look, I will make contact with colleagues internally in the department and see if during the duration of the meeting we can shed further light on it, but I don't have any information here.
So just in respect of where where my 10,000 have come from, according to this memo that we've received, 20 million would be required in order to satisfy the appeals of the 512 that had made appeals. That was subsequently included in your financial statements. But it also said it might require, on the worst case scenario, a HSE estimated potential liability of some €360 million. So in terms of the potential numbers of people, that is where that is being extrapolated from. So it may not be 10,000, but it is certainly running into the thousands of individuals who were denied payments that they were entitled to.
Could I ask you about that? If you can get your officials to get any information before the end of the meeting to come back with it, if you're able to do that. Okay.
We won't be in a position to get any more before the end of the meeting.
If not, can we have a reply within 2 weeks?
Why would you not be able to get information today?
Because, Deputy, it has to be found, and in fairness, we have had some time to consider it, and then we'll absolutely comply with the 2-week requirement.
So, just for clarity, I want to go back to the issue I raised earlier on and just be clear in terms of the questions I'm looking to have answered. So we're dealing with section 38 and 39 residential homes. And these are voluntary community disability services. In many cases, what we're actually talking about is the most vulnerable of the most vulnerable in our society. The HSE advised patients in those settings that they wouldn't be eligible for the nursing home refund scheme. Now, a number applied anyway. My first question that I want to get clarification over the next number of days is how many people in that category actually applied. They were denied on initial count. Most applicants then didn't appeal, again on the basis of advice that was provided to them by the HSE, that they stood no chance of success. But the appeals were made on behalf of 515 residents, as far as I understand it. If we can get clarification on that. They were at St Michael's House, Cheverstown House and the Daughters of Charity. The appeals officer, on the basis of looking at a sample of those cases, deemed that they were eligible. And government, alongside the HSE and the department, decided to initiate legal challenges, bizarrely, to appeal their own appeals officer. but then they withdrew that appeal when they were essentially informed by their own legal instruction that they were 100% guaranteed that a court would deem that there was no legal basis for those residents to have been charged. So as we understand it from the financial statements that we have, the HSE then proceeded to make payments. And my next question is, were all of those 515 appellants actually awarded awarded, and the total sum of that? Now we know from the 2011 memo that the estimated cost of paying those 515 was 20 million, and that figure is stacked up if we look at the financial provisions that were made in the HSE accounts. But from the same memo, we know that there were thousands of residents in those section 38 and 39 voluntary disability services who either, one, didn't apply, or two, applied but then subsequently didn't appeal. And this memo suggests that if they were to be compensated, the cost could be up to 360 million euro. Now, if we look at the 515 for appeals at a cost of 20 million, that works out at 39,000 per case. So if we were to extrapolate that's been applied to the 360 million, that's over 9,000 potential people. I want to get clarity in terms of the actual number of people that would have been affected by that, because what we know from the 2011 memo again is that government ministers approved a strategy of purposely denying those whatever number of people who are eligible information in that regard. So my final questions are, if you can ascertain the total numbers that were affected, essentially how many people were entitled to payment but were denied, whether or not any effort was made by the HSE in the intervening period to contact those people or their guardians to or their descendants to inform them of this, and if not, what will now be done. So I just wanted to be very clear, Chair, in terms of that. I want to ask a question in relation. Go on then.
So the questions definitely are clear, and we'll work on answers. But just I have to say for the record, Chair, there are certain characterisations that you've used there, certain assertions of things as facts, which we wouldn't accept.
Well, so which one would you accept?
Well, I'd have to go through the whole transcript, but use of the words like bizarre and assuming that people acted in a certain way based on certain reasons, we couldn't accept as necessarily as facts until we do establish the facts.
Okay, well, so I'm literally only after saying it about a minute and a half ago. So what did I say that you dispute?
No, sorry, Deputy, we will take away your questions. They'll be in the transcript, and we will faithfully seek to answer those questions. And I've made the point I've made, Chair, for the record.
Well, you've made a point that says you're disputing some of what I've said. I'm asking you, what do you dispute? Do you dispute the word bizarre?
For example, Deputy, I don't wish to be argumentative with you. I dispute the use of the word bizarre.
Okay.
It assumes motive in some respect where we haven't established the facts. So let's establish the facts.
Deputy, just a second. The witnesses, you've asked which parts. What I would ask is that to give the witnesses an opportunity to come back with the reply regarding the numbers, but also if the witnesses come back with what the dispute, right? He's disputing their assertions. So,
well, can I just say this, Chair?
Can
I just say this? If the word in question that has caused concern is bizarre, just to reflect on what I used it in, I said it was bizarre, and I accept that it is a subjective position, but I consider it bizarre that a department would take its own appeals officer decision to the court to appeal it. I think that's a bizarre scenario, and in that instance you're entitled absolutely to have a different view on it. It doesn't actually impact on the specific questions that I put.